understanding the rules of evidence is the key to being able to presenting your evidence and being able to advocate for your client. It's like being able to see an overview of the entire case. And not only you're able to see the overview, but your trier of fact is able to see the overview and see where you're going. Often in trying a domestic case, and when I say often, I mean many times, I have been told by practitioners, well, Judge, they can't object because the rules of evidence don't apply in domestic cases. Well, I will tell you that in my jurisdiction they do, and I'll refer you to the federal rules of evidence because most everybody has adopted this particular provision pretty much verbatim. It tells you the applicability of the rules. And it says these rules apply generally to all civil actions. What's a domestic case? It's a form of a civil case. And Rule 1101 also tells you what it doesn't apply to. Preliminary questions of fact, grand juries, proceedings for extradition or rendition, preliminary examinations in criminal cases, sentencings, revoking probation, and other criminal matters. I don't see anywhere in this rule where it says that the rules don't apply to domestic cases. But that's okay, because if you know how to use the rules, you know how to use them to your advantage, it's going to help you.
The first thing that comes up in any case, and in family court just as well, is storytelling. And I know you're sitting there going, hey, judges don't want to hear stories. Well, you know what? They do want to know what your case is about. And that's what I mean when I talk about storytelling in this context. And why should a judge be interested in that? Because family court dockets are crowded. I checked this morning before we started this webinar. I currently have 366 open case files in my division. Don't you think you want to give me some way of distinguishing your case from the other 365? And how do you do that? By giving me a good story, by helping me understand what the case is about. We always talk about evidence speaking for itself. Well, it doesn't. I got this quote from Errol Morris, who's a documentary filmmaker. Evidence never speaks for itself in spite of all the doctrines that says it does. Evidence always becomes part of an argument, a narrative. And that argument and narrative can be tested against reality. In the law, we have a name for that test against reality, don't we? We call it a trial. So the basic underpinnings of every case is that every case is about stories. Each examination helps tell your client's story of the case. Good storytelling will hold the judge's interest and make her want to hear more about what's going on. And the story you want to tell is your client's version of the facts and how they apply to the law, told in a persuasive and engaging manner. How are we going to do that? Well, first we need to remember this. If you don't tell a believable story, the judge will tell herself her own story. Every one of you has had the experience of thinking you've presented a wonderful, clear case and then get the written order and go, where the heck did that judge come up with this? And then you have to think back and realize, I didn't fill in that blank. She filled in that blank herself. And that I should have done something to give her the bridge to fill it in with the information I wanted.
But I'm going to talk about the rules of evidence and not necessarily just specific problems. But I'm going to talk about just a few things that you ought to always be thinking about as an advocate walking into a family law courtroom. And when Judge McGahee says, and when Judge Weishaupt say, hey, you know what, make sure you know your audience, I can guarantee you this, there is no judge who you're going to try a case in front of who will be disappointed if you know too much about the rules of evidence. In fact, I would contend that if you walk into that courtroom as the advocate who has a better mastery of the rules of evidence than your worthy adversary, the judge will start to rely upon you at times and trust you in ways that will benefit both that client and your future clients. And what I mean by that is when you make objections, you can cite rules. When you respond to objections, you can cite rules. So a command or mastery of the rules of evidence is pivotal for you as a litigator, because that's what we do as family law attorneys. Eventually, we end up in courtrooms. Yes, we can resolve cases short of hearing. Yes, we participate in mediation. Yes, we participate in settlement conferences. But if we have a mastery of the rules of evidence and we can litigate effectively in the courtroom, we're going to continue to get clients and we're going to get good reputations. So I want to talk to you about a few of the rules of evidence you should really be paying attention to every single time you walk into court. And the first one is 201. I suspect that most of you have a pen handy. And what's Rule 201? Rule 201 is what we call the judicial notice rule. And if I remember correctly, it basically says that the court can take judicial notice of facts that generally aren't subject to dispute. It's such as what time the sun rose on a given day, or what the speed limit is in a particular section of highway, things like that. Judicial notice can be a powerful tool for you. Next, let's think about going into 401. Rule 401 talks about relevant evidence. And for those of you who are thinking, I remember relevant evidence from when I went to law school, well, what is relevant evidence? We can look up the definition, or we can just ask ourselves, what makes this important in this case? And if you can answer the question, this is why this is important in this case, you're going to survive a relevance objection, and you yourself will be doing your client a service by presenting evidence that's going to assist Judge McGahee or Judge Weishaupt to make a decision about important things in your case. And lastly, I'm going to talk rapidly about where we tend to find hearsay. We are now seeing a world of social media that, frankly, I'm behind. I don't understand it. And ironically, I was the kid who had to go help my dad hook up the VCR long ago. And today it's my kids who are telling me that there's something called Pinterest, Snapchat, obviously Facebook, which I don't understand IMing on Facebook, but I bet you have kids who do. I don't, but I'm learning it. And I'll tell you this, that in our world of social media, whenever it comes to any social media, whether it's a Facebook post, whether it's the use of text messages, whether it's instant messaging, whatever it possibly is, the rules of evidence don't cease to exist. You have to go through the exact same foundational requirements when it comes to any of those sorts of social media posts that you go through with any other piece of evidence. Number one, does it matter? Is it relevant? Number two, is it what it purports to be? In other words, is it authentic? Number three, are there hearsay issues? And then number four, we could talk about the original writing rule or the best evidence rule, but really that stuff doesn't matter so much when it comes to these things. Know this, that when it comes to social media, when your client walks in and says, look what I found on Facebook, or look at this text message, your analysis has to be exactly the same with any piece of evidence.
Let's talk about some things to avoid so that you're not banging your head against the wall, or that I'm not banging my head against the wall. Too much involvement. It's very easy in family court cases to become too involved emotionally with your client. Even though you're their advocate and you're speaking for them, make sure that you're taking a reasonable way of looking at the case and not getting yourself overwrought and over-involved in it. Ditto too much passion. Even though I'm talking to you about being strong and being forceful, that doesn't mean you can pound the table. Too much volume. Please don't yell at me. It's a small courtroom. I can hear you. Be emphatic, not loud. Pretending bad facts don't exist. This one just stuns me. It's a rare family court case, let's face it, where everybody on one side is pure as the driven snow and everybody on the other side is the essence of evil. If these are adults who have been married for any period of time, there are probably problems with both of them. You cannot run away from the bad facts in your case, and you are probably much better off if you present them and soften them or diminish them during your own presentation.